That is para 4. That has nothing to do with the decision-making process of the governor. No reason. Para 5 quotes the operative part of the resolution of the cabinet. It's a little unfortunate. I'll show one of the most detailed cabinet considerations ever which your lordships can come across.
The operative portion is
That's
quoted.
right. It's a insult, Wallace, to the cabinet to quote this.
No, it's
alone.
a very,
Please.
very detailed, my lord. I wish every state has such a brilliant cabinet which can write legal submissions, my lord, which are borrowed, I think,
So
my
now,
lord.
Wallace,
petition also.
a laconic, unreasoned order of the governor is not blameworthy, but a detailed, legally reasoned order of the cabinet becomes blameworthy because it is reasoned and detailed.
And
This is
possibly
Wallace, Alice in Wonderland.
possibly not written in the
The
cabinet.
governor's order is unreasoned, laconic, with nothing. And that, my learned friend, supports. But he says a cabinet, elected cabinet of the state, and versus an unelected governor, whom I have no hesitation in calling a friendly governor, will ride roughshod over a detailed reason because it's reasoned. Why? Because the reason must have come from lawyers. Is it a crime to consult lawyers, Wallace? This side of the bar would be unemployed, Wallace. Now, come to 6. That is the implication of my learned friend's interruption is, Wallace. Now 6. I have considered the decision of the cabinet. So I'm just showing what has he decided. He decided nothing. I have considered the decision of the cabinet and of the file in relation in hand. It is noticed said file, Siddaramaiah had asked the chief secretary to convene a meeting and to place the show cause and all other material before the cabinet. Accordingly, the cabinet notice was convened. This is also wrong. Cabinet was convened on a separate item agenda with nothing to do with the CM, but I leave that. I have also just see the page 45 is important. Above para 7.
I'm there.
I am also taken note of the fact that the said cabinet was not presided over by Siddaramaiah. That's again a bit of a half-truth. The day the meeting was held, Siddaramaiah didn't attend the meeting at all. There's no question of not presiding over, etc. or recusal. It's not recusal. He didn't attend the meeting at all. In the present case, the petitions have been filed seeking grant of sanction against Siddaramaiah. The resolution of 1/8, the cabinet, has been passed by the... Look at the reason. If this reasoning is correct, Malus, no collegial decision-making, be it the High Court, be it the cabinet, can Malus be safe. Look at this reasoning. The cabinet has been passed by the cabinet colleagues of Sri Siddaramaiah, who have been appointed on his advice. In view of the above and considering the fact that the petitions have been filed seeking sanction for investigation and prosecution, I have also independently examined the petitions. Not a single reason. And Malas, if your lordship were to say that the cabinet, chief minister appoints the cabinet, then Malas, are you rewriting does the constitution allow you any other system? You have to be elected and then you may be appointed. Therefore, the cabinet can't decide anything. The blanket en masse cabinet is disabled because you, the governor, issue a show cause on the same day. Now go further. And he says, I have independently examined the petitions. Let us see the result of that examination. I don't think he has advice of any lesser lawyers. Since the sanction is sought against the chief minister, the surrounding circumstances of placing the show cause notice before the cabinet and the decision advising me to withdraw would not inspire confidence to act on such advice. So he decides, I forget about the advice entire. This is the reasoning. Then Malas. The subject of binding of the advice, so only point he decides is this point. This is the only decision, para 9 according to me, which is Malas, and I am arguing the first point on the assumption that the governor is right in this. On the without prejudice assumption that he's right. I'm not conceding it. The subject of binding advice and discretionary power is well discussed in the case of Madhya Pradesh establishment. Again, Malas, your lordship knows Malas the Mahabharata story of Ashwathama Hatho. Half truth is much more dangerous than a lie. It is right. This is a constitution bench. But Malas, would your lordship cite a 2004 bench without citing Navam Rebia, which is 2016? Which deals with this fully, at least cite it. You reject it, distinguish it, do what you like with it. At least cite it. This is the application of mind, even on the issue of conflict of interest, which is deciding. He's not deciding the matter at all.
Nabam Rebia is...
Then, well, if on these facts and circumstances, the governor cannot act...
Nabam Rebia, possibly you are mistaken, Dr. Singhvi, you have cited wrong judgment. Nabam Rebia is 10th schedule. It has nothing to do with this.
Which one?
Nabam Rabia is on 10th schedule.
I would request.
Defections,
He can't do
anti-defection.
a distinction of a judgment I'm citing in mid-argument, Wallace.
No, I'm
let
saying
me-
possibly
let
you
me
have committed an error.
let me
That's all I'm-
It's only a
Allow me
clarification.
to commit my fundamental right to commit errors, sir. I will
Yes,
show who's
that
committing
of
an
course.
error.
Clarification.
I have a fundamental right to commit an error. I will show you 12 paragraphs of Nabam Revia which deals with MP establishment. Then we'll find out what the error is. 12 paragraphs.
Got it.
And the learned governor, advised by the best lawyers, doesn't have this, Wallace.
The learned SG was wanting to clarify, that's all.
Now, Wallace, it seems to me that there are two. So, Wallace, this is the one para. Well, I have not responded once. When he interrupts me, Wallace, I'll have to respond. It's better he doesn't interrupt me. Then, Wallace, 11.
Yes, sir.
In view of the above facts and circumstances, I am satisfied that sanction can be accorded. Now, Wallace, this
No,
is
no,
the,
9 you were reading.
yes. So, 9, Wallace,
If on the facts
it's
and
just that Madhya Pradesh quoted.
after Madhya Pradesh there is.
Then
some-
10.
No, no, no.
Oh,
Complete-
I'm reading the quotation. Okay, right, very well. I thought your lordship is.
After
If
the
on
quote-
these facts, this is the quotation, Wallace.
Oh, this quotation.
Ah.
Yes, yes, para 10.
Then 10, Wallace. This is from that judgment without citing Nabam Rabia. Upon perusal along with the materials in the petition and subsequent reply and the advice, it seems to me that there are two versions, same set of facts. It is very necessary that a neutral, objective, and non-partisan investigation should be conducted. I'm a prima facie satisfied. Where is the reason? Whereas reasons are said to be the process of ratiocination, which link the material with the conclusion. This is the conclusion. There is no reason here. Then, in view of the above fact, I am satisfied that sanction can be accorded against Siddaramaiah as mentioned in the petitions. Now my lord gets the again natural justice answer. Ibrahim, Pradeep, and Krishna. Hence I accord sanction, mark the next line, under 17A. So, Malas, there are two ways. One is this sanction, let us assume, decides one point. I'm not conceding anything. Please appreciate what I'm saying. I'm making it simple for today, Malas. He decides only and only, let me assume that my learned friend is right about MP establishment. I'm not going into it. It only decides that the governor can, in some cases, decide matters not listed in 163 and is therefore not bound by the cabinet. So I, for a minute, without prejudice, accept that. I don't concede it at all. I accept that he can treat the cabinet as rubbish and say, I'm not bound by the cabinet. Even then, he has to give a lordship a reason why he's granting sanction. Where is that reason is my question to myself. I find no answer. The governor's impugned order is eloquently silent about a single reason as to why sanction ought to be granted on the facts, on the merits, on the issues, on the reasons, etc., etc. And that is sufficient to quash it actually. Now just see two judgments on the governor's sanction issue directly of your lordship's and both I think have a Karnataka connection. At least one of them does. Kindly come to us.
Copies are given.
Yes, the first one is Mansukha, 1997. Give it to the other side also once. Just give one first to him.
Abhishek, can you please repeat the citation?
Yes,
1997, you said.
volume 7 SCC 622.
Thank you.
What is this?
97.
Now in this fellows, note 3 paragraphs, 14. This is on the sanction. You are the governor giving sanction. How the sanction is to be looked at. Para 14.
Yes. At page 262.
Of the you give some other compilation to him or something. I'm sorry.
Does it begin with as has been mentioned above?
Oh, I see. There's also different citation given. You give me something else and you give me some other citation. Yes, this is a different citation. This is SCC online.
Oh, it's SCC or Manupatra?
Open para 12. Just show me the judgment now. Yes, I'm very sorry, but this is the problem. Page number.
Justice Sagir Ahmad's judgment, right? Ah.
Yes.
From a perusal of section 6, does it begin that way? Yes, Mansuklal Vitaldas Chavan. Yes, this. Once a person against whom-
against whom, yes, but that's, my copy starts with that, my lord, it's SCC. Possibly Dr. Singhvi has the SCC online copy.
Para 14. Next page, para
I think, sir, you're referring to para 14.
17. Correct. 14.
Possibly Dr. Singhvi has
Better
SCC
if same
online.
copies are given. What is this?
But online has some page in paragraph difference.
And I see here some Manupatra judgments are there, some SCC. What is this?
Give me a minute. You don't even have the judgment in your hand. What are you showing me the index for? Take out the judgment. I'm very sorry. Bala.
No, no. No, this, what you say, I think is at para 14, sir.
Abhishek, you possibly have, Abhishek, you have SCC online. Paras differ in SCC online and SCC print.
I'm trying to find the corresponding para for my lord.
It starts from where? I'll help you. It starts from what? Your para starts from where?
Well, my para reads like this from a perusal of section.
That is para 14, sir. Para 14.
That is para 14 of SCC.
Page 262.
The one which my lord has got that para 14.
I have this from a perusal of section
Very
6.
That is para 14 of SCC printed version.
So can you want a copy of
Add
this?
something, what are you doing? Even what you've given him and what you've given him is different.
No, it's better if same copies are there.
From a perusal of
Yes.
section 6, it would appear that the central or state government or any other authority, depending upon the category of the public servant, has the right to consider the facts of each case and to decide whether the public servant is to be prosecuted or not. Since the section clearly prohibits the court from taking cognizance, etc. Leave this one, now come to 17. Now look at the next one. Don't justify this. Forget this. Sanction lifts the bar for prosecution. The grant of sanction is not an idle formality or an acrimonious exercise, but a solemn and sacrosanct act which affords protection to government servants against frivolous prosecutions. Mohammed Iqbal Ahmed. Sanction is a weapon to ensure discouragement of frivolous and vexatious prosecution and is a safeguard for the innocent but not a shield for the guilty. 18. The validity would therefore depend upon the material placed before the sanctioning authority. Mark the word material place.
Yes.
And the fact that all the relevant facts, material and evidence have been considered. And the fact that all relevant facts, material and evidence have been considered by the sanctioning authority. Consideration implies application of mind. The order of sanction must ex facie disclose that the sanctioning authority had considered the evidence and other material.
One clarification. We have not yet gone to the stage of sanction. In the sense, the case is not advanced to the stage of sanction. 17A is mere approval.
That's,
No, 17A is up. So that's
No,
that's
the whole problem is 17A is mere approval, but what is quoted in the order is 218 also.
A. B. 17A itself, the point I'm coming to, was you can't do it without two conditions precedent.
That's what.
So,
Yes.
but let us kindly see the problem. Your lordship is absolutely right. You adopt a pre-17, a pre-sanction stage in a technical sense. Then you violate even that pre-sanction stage 17A because there's no police officer, there is no recommendation or decision by me.
Hmm.
And then actually while writing it, you bring in 218 also. Then where do I go? Tomorrow, can I argue this before the criminal court? I have to tell the writ court, where is the reason for all this? My lord is absolutely right. It's a completely jumbled up order.
No. In the sense, what you're now referring to is sanction. Sanction is akin to section 19 of the PC Act.
But
17A is approval for inquiry,
I-
inquiry or investigation.
But what I'm saying, the principle I'm in here is not on sanction alone. I'm on application of
Oh,
mind. That's
That-
all. I'm only on 17 on application of mind.
That's all.
Malas, two sentences. One, he must have all the material placed before him. Two, he must, this para says,
Yes.
must show application of mind to that material. What your lordship has, not what Malas, I may be thinking elsewhere. Then Malas, just to end this, 18. 18 I've done, 19. Again, fourth line, Malas.
Yes.
It necessarily follows that the sanctioning authority, it may not be technically sanctioning, it may be 17A authority, any authority.
No, then 17A was not in the statute book, so
Also-
sanction was the
also-
only
Only
thing.
19 was
I'm
there.
grateful.
Yes.
Has to apply its own independent mind for generation of genuine satisfaction. Kindly see the next,
Yes,
19 fourth line.
yes,
It necessarily follows the sanctioning authority has to apply its own independent mind for the generation of genuine satisfaction whether prosecution has to be sanctioned or not. The mind of the sanctioning authority should not be under pressure from any quarter, nor should external. Yes, absolutely, its discretion should be shown to or not have been affected, etc. Now, this must reflect from the order. Matlab, I may be wrong or I may be right. I have placed the order as it is read. I can't add to the order. The order decides one thing and I'm for a minute conceding it. I'm not accepting it, I'm conceding it. It says, your cabinet decision is not binding on me. And the reason I give is CM and cabinet is the same and MP establishment. QED. I accept that for a minute. My question to myself is, where has the rest of the decision gone? Then, Malas, the same thing is Yedurappa. Malas, there has been rich contribution to jurisprudence, Malas, by that name also. There are many judgments. This one, Malas, is a judgment at 858. I hope the pages match this time.
858.
Yes. This is the division bench of Karnataka, which holds the field. There is no Malas contrary thing in the in the Supreme Court, etc.
Hmm.
And your lordship will just give me a minute for it. In this, come to para 22 onwards. Leave it. Look at this, verse 22. And look at the considerations rightly taken by having heard the learned counsel for the parties and perusal of the record, we are of the opinion that as the complaint was a private person, a private complaint, great care, caution, and proper application of mind were necessary,
Yes,
particularly having regard to the uneasy relationship between the then chief minister and the then governor.
yes.
If a crime was registered followed by investigation for collection of evidence, both oral and documentary, the governor could have in the hands materials for application of mind. The investigation agency could also have recorded the statement of the accused, as the allegation was of acquisition of assets disproportionate. Then, Malas, 23, we will skip. 24 is 197.
Yes.
Now, Malas, 218, etc.
Hmm.
Do not lead to needless or vexatious prosecution. Well, this is the larger issue is if you accept the principle, then no elected government can be safe. Then, Malas, assuming for the sake of argument, the public servant is acted in excess of his duties, but there is reasonable connection between the act and the performance, the excess will not be sufficient ground. Then, Malas, they give the history 25, 26, etc. and come to 28. We know our limitations in considering the writ, but we are not concerned. We are concerned with the decision-making process. We have carefully gone through the order of sanction. With respect, the governor has quoted the complaint in detail in his order of sanction. Virtually, there is no finding as to why he has accorded sanction in favor of the prosecution. There is no discussion.
He's reading from the written.
And then, Malas, the judgment cited against me
Same
itself is cited and applied rightly in my favor. The governor cites this judgment, same judgment. Held that there could be matters where the governor could act in his discretion, even though the constitution not expressly so provided. The governor was therefore free to differ from his counsel. That also was not when the chief minister is nowhere near the decision making. In this case, he is nowhere near decision making. But I leave that. But no reason was mentioned as to why he was not accepting the opinion. No reason. There was also no reference to the said letter dated 19th or the